G'day, everyone, and welcome back to your favorite trial lawyer and high performer podcast. Courtney here, and the one and only Sean Claggett from Claggett Sykes out of Las Vegas, Nevada. Sort of beginning, what do you think is the one, or maybe there's more than one, case that kind of took you to the next level as an attorney?
Well, I would say certainly the case that put me on the map was the case I had against Lowe's back 7 years ago or so. It was a case where I waived $600,000 in meds, and all the old guard trial lawyers in Vegas were like, "This kid's committing malpractice. What is he doing?" Blah, 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 blah. And I'm like, well, kind of is what it is. I think it's the right thing to do. I'm convinced it is. It's a brain injury case, and I don't think $600,000 is all that much when I know I'm going to be asking for $40 million.
Right.
And so that was a really hard case too on liability, because my lady had slipped and fallen and knocked down a yellow cone. And so not only am I taking what many felt was the impossible liability case, but then I'm going to waive $600,000 in meds. They're like, this kid's a walking case of malpractice. But what I knew, because I had done about 20 focus groups, I knew that the yellow cone was actually my strongest part of the case, because the yellow cone actually meant that there was a problem that they were aware of and they were fixing it. But Lowe's created the hazard by overwatering in their garden center, and they just left the cones out to blame their guest if they fell. And they knew the guests were going to fall because they fall all the time in the garden center. And by the way, it's still the same thing today. It hasn't changed. And so, Lowe's is doing the same stuff that they did before. So, but the verdict in that was $16.4 million and change. And I thought that, I always told myself, man, when I get an 8-figure verdict, I will have made it. It was the worst verdict ever for me, because everybody said I was a fraud. I got hit lightning in a bottle, it was like this one-hit wonder. And all of a sudden I'm hearing everybody talk, and I'm like, oh my gosh, this is terrible. I need to go do another trial immediately. And so I went and I did that next trial where I got 20 million. And then all of a sudden people are like, oh, maybe he knows what he's doing. And then, we had a few others we did along the way that were, multi-million-dollar cases. And all of a sudden everybody's like, oh, he's figured something out. And I think that's true, right? I mean, I think once you figure it out and you figure out the system that works and you're committed to it and not arrogant about it, right? I've seen some attorneys hit some really big cases and then get their butts kicked over and over and over again after. And that's because there was a process that probably worked and they either strayed from it, or, it could have been a lightning in a bottle for some lawyers. I don't really believe that to be true too often. But we've created a system that we know works. And the part for me that's super cool is when we work with attorneys that have never had $1 million verdict and they go get an 8-figure verdict with us, consulting with them. And we've seen that over and over and over and over again. When I was just doing the trial that just wrapped up where we got $485 million, in that same couple weeks span, we had 2 cases that we had consulted on with attorneys who had never had $1 million verdicts get $52 million and $25.5 million respectively. That was cool. I actually got more excited for their verdicts than for my verdict, because my verdict, I already knew I was going to go big.
Right.
But for them, I knew that they had the potential, but they'd never done it. And then to see the joy and happiness where they feel like, man, I'm there. I'm amongst you guys now, real trial lawyers. I can walk in a room and say, I'm a real trial lawyer. That's got great value.
Yeah, I love that. And speaking of the cone case, was there something about you maybe having a cone in the courtroom, or the cone was hidden from people? Can you talk a little bit more about that? Because that sounds very funny.
Yeah, so this was, it was a cool moment, right? So I'm real creative in trial. I've always been very creative. It stems from doing criminal defense and having to be super creative to figure out ways to deal with really bad facts. And so during that trial, I was thinking, how can I explain to the jury that my lady never saw the yellow cone? Because it was tucked around a table, and she was walking, looking at a palm tree. And by the time she got to the cone was in the hazard. And I'm like, but if there's distractions, it could be right there, but you're not going to see it. So I finally figured out, I'm like, oh, you know what I can do for closing is the witness box, which every single juror has to walk right by, it was like 32 inches high. And so I put some tissue boxes and water jugs along the edge so that when they walked in, if they didn't look right at it, they'd miss it. So during my closing argument, I was explaining how my client didn't see it. I'm like, but when the cone is behind the flowers and around the corner and obstructed, she didn't see it. And then I walked into the witness box and I grabbed the yellow cone. I go, just like none of you saw this. And that's how we know she didn't see it, because none of you all walked by this today and never saw it.
Oh my gosh.
Yeah, it was a pretty cool, and none of my team knew what I was doing. I didn't tell anybody. But I did tell the client, I said, hey, at 42 minutes into my closing, I'm going to do something for you. And so I had my co-counsel tell me when I got to 41 minutes, so I knew when to start my little bit, and that's what I did. And so they knew right at 42 minutes, I pulled it out, and it was pretty cool. I want to say it was 42 or 45. I can't remember now, but it was like right around that time frame. But I had it all set up and planned with the client to show them.
I love that. Speaking of another case, one from this year, your client, Amy, was the victim of medical negligence. And I did read a little bit about her story, which the human story on this, I mean, it's like a heartbreaking case. And obviously you got really great justice for her and her family. But do you want to talk a little bit about that and kind of the background of that case too?
Yeah, that was a really sad case where our client, her husband was sick with terminal cancer during the holidays, and she was depressed, not taking care of herself, and she ended up having really low sodium. When we have low sodium, it's called hyponatremia. Hypo meaning low, and natremia meaning the sodium. The low sodium causes people to think that you're drunk, or because your balance is not good and you get confused. So she appeared to the people around her that she was drunk, and they couldn't figure it out. She was having like a glass of wine every now and then, but it wasn't like she wasn't excessively drinking. She just wasn't eating. And so she had really bad sodium. She fell and broke her nose, and her sister-in-law, who she was living with her husband, who the sister-in-law and the husband were brother and sister, she calls an ambulance. Her husband's in the hospital, in a hospital, receiving treatment already. She goes and gets taken to a different hospital where they do initial testing, figure out that she got really low sodium, give her a bag of saline very quickly, and then never test her. They didn't retest her, and they finally did retest her, but they never got the results. And then they decided to send her to a much lower acute facility. And it was done for monetary reasons with the hospitalist. His partner was not able to pass the board exam, so he didn't have privileges at the hospitals. So he contacted his associate, said, send this lady over here. We can bill a lot for somebody in her condition because we'll keep her. And they didn't know what to do. And so ultimately they overcorrected the sodium too quickly, which fries the brainstem and causes locked-in syndrome, which means that your brain is fully functional, but it cannot communicate with your body. So you're completely paralyzed, can't talk, can't move. And every day it's like you're just stuck there. It's terrible. And then the husband died, a few weeks after this happened. A few weeks after this happened, he died. The judge didn't allow the jury to hear any of that. This was the worst judge I've ever had in a trial. She was lazy, incompetent, vengeful almost. Like she really hated me so much that she was doing everything she could to make us lose the case. Like, it got so ridiculous that, like, the defense failed to disclose this critical document that we had subpoenaed. We subpoenaed a witness who showed up with it, and the witness had their own counsel, and the counsel's like, hey, there's a confidentiality provision in this, but it is directly related. So, Judge, we need you to tell us that my witness can testify about what's contained within the document. And the judge says, well, let me look at it in camera. And she looks at it and comes out and she goes, no, not going to let this witness testify about it. It's overly prejudicial to the hospital. I'm like, you mean the people that should have produced it to me, Judge? And she's like, well, it doesn't matter. If the witness talks about it, I'm declaring a mistrial and it'll be your fault. And I'm just like, wow. I go, so you're not sanctioning the hospital for not disclosing this directly most material. This is their entire defense that they've raised in this case, and they lied about it. They lied about it, and we have the evidence, and you've seen it, and now you're telling me that we can't use that evidence because we didn't disclose it, but we never had it. They had it. That's how ridiculous it was. And so I will tell you, it was such a bad experience. We got a $47 million verdict, mind you. But the experience of having her as a judge was so disheartening every day that when I got done with that trial, I had to go. I had that trial, then I had two more that I had to get done. And then I finally had a break in May. And I just told everybody in the office, I'm like, I need the month off. I need to go reset, like hard reset. And pull it together, like want to keep doing this, because after that trial, every way that you could get screwed by a judge, we got screwed in that case. I'm so happy that we got a verdict. When the judge read the verdict, when she saw the verdict, she was distraught because she thought she had done enough to make us lose. We haven't lost a trial in a long time. And so we're, you know how it is. It's like you're a mark, right? Like the idea of beating Sean Claggett at trial is like, that's a big feather in some defense lawyers' hat. And this judge wanted it to happen so bad, so bad. And when it didn't, she was just like, she was straight up, like you could tell she was distraught. The worst judge, and I've had some judges that aren't very good. This judge is the worst judge I've ever seen. And we've all had the worst judge ever. We've all had it. I now have an appreciation for moderately bad judges. I will take a moderately bad judge all day, every day, and not complain. After this judge has set the bar so low that you could be a pretty cruddy judge, and I'm be like, you know what, you're not bad, Your Honor. I've had much worse.
So last question, hopefully with a better judge, your recent case in New Mexico, which was a, record-setting case, huge verdict against a healthcare giant. Do you want to talk a little bit about that? Because that's kind of the numbers that come out of that are so unique that this is not something that a lot of people will ever experience in their law career. So how does it feel for you? And tell me more about that case.
Yeah, so there's three of these cases that we have. I've been involved in this case actually from the very beginning, which has been an honor to represent these three very young girls. They were 5, 8, and 12 when these events took place. But Acadia Healthcare company is the largest provider of mental health care in America. They're huge. Publicly traded, $7.5 billion market cap company. Very, very big. In New Mexico, they had a residential treatment center for the children, which was like, honestly, it felt like a prison. Like, had tall chain link fences. It was a big campus. And that's where kids would go. But they also had a nonprofit arm that did treatment foster care. And the treatment foster care parent involved in this had been accused by girls over the previous 15 years, 16 years of raping them. and he never been convicted, but it was all of these allegations of rape, and they kept placing the kids in the house. And then, yeah, crazy. He was raping all the kids that made the allegations. He probably raped, I can't even imagine how many children he's abused. He pled guilty to raping 6 of them. And three of which were my clients. And so this trial was really about that. And then we had worked so hard. I mean, there was 3 separate law firms all working really, really, really hard on this case, doing great work together. I really was an honor to work with all these firms, because everybody, oftentimes when you do like work on big cases, one firm ends up doing most of the work, right? And the other firms don't carry their weight. In this particular situation, every single lawyer carried their weight. It was a really cool team to be a part of. And so we do the trial, and we had done big data before, multiple big data studies. In fact, I believe we did 3 of them. And the reason why we kept doing them is because we were not getting pushback on my ask. So in the original big data that we did a top ask of $325 million with an expected return around 200. But we got no pushback. Like, nobody was fighting me on the 325. I'm like, well, that's not enough. And so we kept testing it to the point that we finally got like, okay, you've reached the number on the upside of what people will say, okay, that's reasonable still. That number was $1.2 billion. Okay. It was a very large number. Now, we tried this case, interestingly enough, in the poorest county in America. Rio Arriba County in New Mexico is the poorest county in America. It is where we did the trial in Tierra Amarilla. The courthouse is very old. We lost power during the trial. We lost water during the trial. There was most of the structure, the vast majority of the structures around the courthouse had fallen down and were dilapidated. I mean, it was surreal. There was no restaurants, there was no gas stations, there was no hotels, nothing in this town. And it was very symbolic of how poor the community is. We obtained that verdict with those jurors, because what we knew from our data is it didn't matter who the jurors were. This egregious behavior wasn't going to be tolerated, and it didn't matter. And the defense really loved this. They loved the venue. They were like, this is a good venue. You know, there's no way you're going to get a lot of money there. And so they had suggested $3 million, $3 million total for this little girl. And they said, well, you know, she can buy braces with that. She can buy a car. She can buy a house. She can pay for her education, and give her a couple million more bucks. And in rebuttal, I said, well, look, all the things that they just said about everything she can buy with $3 million, she's still a rape victim and lives with that every day. But at least we now know what Acadia Healthcare values rape of children at, and it's $4 an hour. That's the value of their number for the rest of her life, $4 an hour. But at least we know that's what they valued at. And I said, this company only speaks one language, and it's money. And they're looking for a massive discount. Don't give it to them. They don't deserve it. They came back at $485 million.
Yeah. I mean, and which, there's no amount of money that can ever take the pain away from the children, but it's great to hear that there is at least people like yourself that go out and stand up for people that are in these situations. You just brought up something that's really interesting, and it was a question that I had if we had enough time, but it's worked in perfectly. John Romano, which I'm sure you know very well, he's usually probably a speaker alongside you at many of the conferences. He said to me once about, trial lawyer myths, like myths that people have in their mind about this is a conservative venue, or you can't get to trial, or just different things that people believe that aren't true. And you've just proven with this story that the poorest town or city in America can bring back this type of verdict. What do you have to say about that? Those like myths that you hear as well, probably.
Yeah. First of all, John Romano, when you want to talk about being kind and working hard, there's your role model. John Romano is one of the kindest people you will ever meet, and he works his ass off. And it's just like, that's why he's successful. And that's why people are drawn to him and his wife. I mean, you want to talk about the nicest people, the Romanos, the nicest. They're just so wonderful. And I'm not talking about his ability as a lawyer. I'm talking about human goodness. And they're really kind. So if you ever get the chance to meet John Romano, do it, and you'll understand what I'm saying. He's just that kind. And so, yes, we love John Romano at our firm. He's a wonderful person. So, but yeah, the myths of venue, it's interesting. John Campbell and I, with the big data, we used to, when we started doing big data, we're like, oh, we need to pull all the jurors from the venue that we're going to be doing the trial. And then came, I wonder if that's right. Is that right? Do you think that's right? I'm not sure if it's right. Why don't we figure it out, right? Because John and I are both professors at law schools. John's a full professor at University of Denver. At least he was. I think he's still faculty. I don't know that he's full tenured professor anymore because he's doing the big data stuff and lives in Spain. But John and I said, why don't we test it and find out? Maybe it doesn't matter, right? Because is there really a difference between the Trump supporter from Milwaukee, Wisconsin, and the Trump supporter from Las Vegas, Nevada? The 28-year-old uneducated white guy that is huge Trump, or are they actually very similar no matter where they're at? And so John and I started doing these big data studies and pulling them from everywhere and getting the data studies back, and then having the people go and ask for the number that the data suggests. And we're finding out that, it doesn't matter, because the characteristics of the person are what matters. Where they're from actually doesn't end up mattering nearly at all, which is fascinating, right? Because in my big data study for the New Mexico verdict, it was 511 million is what the data projected. So we got within 4% of that.
Wow. That's amazing.
Right. And obviously you couldn't pull, the people we tested were all over the country. And it just doesn't matter. So that myth, we create the myth, right? We create the myth because we go into these conservative venues and like, well, we can't ask for too much. And so we're going to ask for a little bit. But what we've also learned from the data is when you don't ask for enough money, you actually hurt your chance of winning. Because the thing about the psychology there is that the jury is hearing the story and they've got a number in their head that they think it's worth. And then you say a number and it's way lower. Now they think, oh, he's not telling us something. That I'm distrusting now the information. So you could have aligned them up. And by knowing what the right number is to ask for, you're going to align them with you because you already know that that's the number that most people are going to want to see and how they're going to respond to it. So it's very, very important. And I will tell you the most fascinating thing, we have a book coming out. John Campbell and Alicia Campbell and myself have a book coming out, and it's talking about big data. And one of the fascinating things, I find it just phenomenally fascinating, is what you ask for, the amount, is the number one reason for vastly different verdicts on the same set of facts. Because we know this because we've done test after test after test, and we have tons of cases gone to verdict to know that what we're saying is actually true. And that is that when you're asking for a sum of money, all facts being exactly the same, and you ask, say it's 10 million, you're going to ask for 10, 20, or 30. You don't know what the right number is. But what I can definitively show is that in most cases, what you ask for will impact your win rate and what you get from the jury. And we're talking millions of dollars per case. It's fascinating and scary as hell, because you know what almost every lawyer does with what they ask for at trial? They make it up. They make it up. It's not based on anything. We've just said, hey, stop making it up and go to trial with a plan and a number that you've tested and know that it works, and go execute your game plan and get the result that is most likely to happen. So it's a fascinating, the big data is changing. It's a industry disruptor, because the defense will start doing it. Some of them already do it. And if you don't know the big data value of your case, you are in danger of leaving a lot of money on the table.
And I think that's a great follow-up episode, Sean, going into more about the data and what you do in your book coming out, because as you said, it's like you can actually come into trial. I always call it your war chest with your tools that you need for the fight. And it just can't be a gut instinct, which is a tiny bit of what you need. And having this behind you makes it's based on something in reality, which I love. So leaving the actual trial, we're going to transition to trial prep. In my investigation of the one and only Sean Claggett, I did hear that you're an extremely prepared person. How do you prepare for trial?
So Matt Granda and Jordan Logan in my office are both military veterans. Matt's a Marine and Jordan is Air Force. And one thing that they bring with them is a very keen understanding of preparation, right? Because in their prior worlds, if you weren't prepared, people died, and you had to have a plan. And the systems that they employed were done to protect lives. And so they've basically taken that same idea of, hey, we're going to have a checklist. And we're going to do things, and we're going to make sure that it gets done and it's done appropriately. And so what we had was Will Sykes and Jordan Logan and myself came up with checklist, along with Matt kind of helps put it all together. But we have a discovery checklist, and then we have trial checklists. So when we do our work days internally, so Jordan and I, the way it's set up is we're the trial guys. We're just getting ready for trial all the time, either our own trials, attorneys in our firm's trial, or outside firms' trials. But that's our full-time job. All we're doing is getting ready for trial all the time. We have a system where we say, this is what we need from you to be prepared for our work days, so that when you come to us, we can get your order of proof, your jury selection, and your opening statement done. And that checklist, it seems pretty simple, but damn, it's really a lot of work to get done. And it requires a lot of thoughtful preparation. But once you have it, and part of that is we want the big data study done. And just to do a big data study, you have to be super prepared, because you got to write a statement for the plaintiff and a statement for the defense. And you got to make them robust. And so if you make a robust defense opening statement, it makes you think about all the ways you could possibly lose. You want to test them. But by doing that, if you've done the big data statement, we know that you're going to be prepared in large part. And then when you answer our questionnaires, our checklist, it's so awesome, because you walk out a couple days later and you know what order you're going to call the witnesses, you know what documents each witness is going to get in, and you have your opening statement. Well, all you're going to do is take the opening statement as your roadmap for trial, and prove everything that you told the jury you'd prove, and you know you're going to win. And we've done that system with lawyer after lawyer after lawyer after lawyer. In fact, we're working with John Romano right now. I'm very excited. We're also working with the great Satch Oliver out of Arkansas. Those are really fun guys to work with, because you're starting at a very high level, right? But what we know is our system, we can work with the greats, the Satch Olivers and John Romanos of the world, and we can work with attorneys who've never had $1 million verdict. And if you buy into the system, the results are going to always, they work out. Because if we have the big data and we know you're going to win, the question is, how do we tell the story to make sure that you get that number? And so Jordan Logan and I have become really experts in doing that. And, we probably do about 20 to 30 trials a year, either ourselves or consulting on them. And so it makes it a blast. And again, the joy I get out of somebody else getting a verdict is always much higher than getting my own verdict.
Yeah, we spoke about that actually for everyone. Well, you wouldn't know, but I saw Sean just on the weekend in Vegas. He had a great firm party catch up. It was great to see everyone on the team in person. But speaking of trial prep, you have a baseball background, and my limited Australian knowledge tells me that baseball people sometimes have special superstitions or routines that they do before they do things. Is there one thing that you do before trial that you're like, I have to do this every time, or wear this, or I don't know? Is there something that's specific to you?
So I do. I will shave my beard off the night before opening statements, or night before voir dire, rather, so that I'm clean shaven. And I do that for every trial. I don't know why, but I've just done it. And I figured it's a good luck thing. And then that's really the main thing that I do. And then, of course, I wear my cowboy boots during all my trials. And that's more of I always laugh when I see the attorney that wears their cowboy boots in response to me wearing boots, trying to connect. And then, like in this last trial, this attorney from Colorado, in the middle of trial, he all of a sudden has a pair of cowboy boots on. I'm like, oh, we're in the parking lot after the day of trial. I'm like, hey, can I give you a piece of advice? I go, those are some sweet boots. But if you're going to wear boots, have a boot cut pant, man, because your pants were stuck up in your boots the whole day, and it looks silly because he doesn't actually wear boots with his suits, because if you're going to wear cowboy boots, everybody knows that wear boots, you got to have a boot cut, to make room for the boot. And so you can tell the lawyers that wear cowboy boots all the time and the guys that are being posers and trying to wear cowboy boots at a trial, but they don't really wear cowboy boots. So I got a hoot out of that.
That's funny. I always say up in Montana, you can tell the first time boot wearers because they are walking funny because they already have blisters because they haven't worn their boots in yet. And so where the ankle pad is rubbing on them, you can see because they're kind of walking with a very strange stride. And you're like, oh yeah, they just went to Boot Barn. But we have 2 questions left. This has been great. This first one is for other people and the last one is for you. So kind of leaving off today, if you're going to leave the listeners and their experience, there's newbies, there's people in law school, what's just one bit of advice that you could leave with trial lawyers today?
The best advice I could give anybody is that use the resources that are readily available. The COVID was a very unique time for all of us. We had to reinvent the way that we were teaching how to do trials, right? Because we couldn't be in person. And what came out of it was I think the best way to ever teach. And that is to watch people doing trial and hear those very people pause the video and say, this is what's going on and this is why I did it. I've always said that if you understand the why, you can use that as a tool. But if you understand why something's happening, you'll never be able to actually effectively use it because you don't know why it was used. And during COVID, the best trial lawyers on the planet all came together. And on, the Trial Lawyers University, there's a very cheap library for an annual subscription. I make no money off of this. I want everybody to understand this. I make not a dime. But if I would have had access to that in the first 10 years of my practice, 12 years of my practice, I'd be so much better today. And I tell that to all the young lawyers in my office. I'm like, take advantage of this. Like, go, if you spend an hour a day working out, on the treadmill or on a bike or whatever you're doing your cardio, and you're watching this, you're going to pick up so much stuff, and then go practice it. I can't stress enough how important focus groups are to practice what you've learned, because you learn these techniques and then you see them, but can you pull them off in front of a group of strangers? You got to practice. And focus groups is what gives you the practice, because the successful trial lawyers, if you watch them all, we all have vastly different personalities. John Romano's personality is very different than mine. Rick Friedman's personality is different than both of ours. Brian Panish's is different. Nick Rowley's is different. We all have these wildly different personalities. But when we go in front of a jury, we're horrifically authentic. Right? Maybe that's not the right description, but it's the truth. Like, better or worse, we are our authentic selves in front of the jury. And that becomes very important, because people believe you when you're authentic. You're trustworthy. But you can only be authentic if you're comfortable. If you're uncomfortable, you're not authentic. If you're not authentic, you're not believable. If you're not believable, you're not going to win your cases very much. And so that's what we try to talk about. And this is what focus groups allow you to do, because when you do a whole lot of focus groups, and then you have to go pick a jury in front of a group of strangers, and then you're like, this feels an awful lot like just another focus group. And you're like, big breath, I've been here, done that a million times. And then you're comfortable. And then you literally are just having a conversation. There was a attorney in Vegas, long-time attorney, very experienced trial lawyer, and he asked me to do a trial with him. I said, sure. And we did the trial, and he was like, afterwards, he's like, your voir dire was the greatest thing I've ever seen in my life. You literally just had a conversation with the jurors. You were so relaxed. That was amazing. And I'm like, yeah, I mean, when you do, I've done like 800 live focus groups. So when you've done that many live focus groups, picking a jury becomes second nature, and you are very authentic. So that would be my absolute advice to young and, experienced and inexperienced trial lawyers. Do a lot of focus groups, even if you're not doing them exactly right. The benefit you're getting from doing them is being comfortable in front of strangers.
That's very good advice. Now, last question. I can't believe we're at the end. This one's for you. So I listen to, probably like yourself, tons of different podcasts, tons of different genres. One of them is like a kind of funny one. Well, not funny, but like different. Alison Dubois. She was there was a TV show, Medium, back in the day. She's a medium that works with the police, homicide stuff. And she always has this question. She's like, imagine you're at the end of your life. It's been a great life. You're wherever you're going to go. It's the pearly gates. It's the never ending baseball field. For me, it's like just a million cats waiting for me to cuddle them. When you think about yourself, what is one characteristic that you would want to take with you and one that you would want to leave behind?
Oof. Well, the one I would take with me is the love I have for my family. Being a trial lawyer, it dominates your time. But I've done the best I can. And I spent a lot of time, like this afternoon, I'll be going to my daughter's soccer game, right? So it's high on my priority list. So I would take that one with me. I think the one that I would leave, ooh, that's a tough one. I think it would be the trying to please everybody all the time, never saying no. Like I say yes to way too much, and I end up being pretty thin on time. And so those two things that I love, the trait that I spend with my family, but I end up oftentimes sacrificing personal time, which I think we all need. And so I'm trying to do better with that. Like my wife and I literally had a conversation about that. this morning about what my schedule should look like. We're almost out of digging out of all the COVID backlog. And so what does my future look like? And how many trials a year do I really want to do? And what does it all mean? And so those are questions that I'm constantly asking myself and always searching. And by the way, the answer changes all the time, which tells me that I don't really know the answer. And I just had a case brought to me that it's so good. It's such a good case. And I really should say no to the trial, but I'm like, no way, man. If I can do this trial, that's the problem, right? Is like it's such a good case. And I was like, when they were telling me, they were like, you think this case is worth like high 7 figures? I'm like, no, I think this case is worth 9 figures. I mean, that's how much I like the case. It's like, it's a really good case. And I'm like, I think you're going to can I try it? Because I'm literally going to go from that trial to another trial. But I was like, and I shouldn't do that to myself. And I know for all my other goals that I'm saying, hey, don't, but then like it's in front of a great judge. It's a great fact pattern and it's a huge verdict waiting to happen. I'm like, you kind of want to do it. So I don't know. I'm always, I'm struggling. I wish that I'd be consistent with my answer about what I wanted to do, but it changes. I'm the most inconsistent person about what I want to do moving forward, because I know a big part of me does want to slow down. A big part of me does want to enjoy. I love golf. I'd love to really play golf on Friday. Sounds awesome. And I've never done it. I just never give myself a Friday to do that. And my wife's like, you really need to do that. So we'll see. I'm going to have an amazing physical at Scripps in San Diego on Friday this week. And the doctors may make me slow down. We'll see.
They might change your answer then. But I always say, I think there's a bit of a leeway when you have to sacrifice something for your calling, which, being a trial lawyer obviously is your calling. So I think the universe looks on that and gives you a bit of a wink and they're like, that's fine. So, well, Sean, thank you so much for coming on the podcast. I hope you've enjoyed yourself.
Oh, this has been great. I'm glad that it worked out. I know we were talking about doing this for a while and then my trial got continued and here we are. We have a little bit of free time and we took advantage of it.
Yeah, no, it's been wonderful. And I definitely want to get into the big data stuff on another episode with yourself and John. But for everyone who listens to the podcast, like, comment, and subscribe. Keep us in the top 3 of Trial Lawyer podcasts. Also, Sean, before we go, how do people get in touch with you after today's episode? Maybe they want to co-counsel a case. They have questions for you. What's the best way for them to reach out?
Shoot me an email at Sean, SEAN, at ClaggettLaw.com. That's CLAGGETTLAW.com.
Perfect. Well, he is a very busy man, but I'm sure if you have questions for him, he loves to teach and help other fellow trial lawyers out there. So don't be a stranger. And thank you, Sean, once again.